I actually want to ask you, because this comes up in an Australian Financial Review article printed in 2000, and you're quoted here. It's an interesting quote here. It talks about one of your own case losses, the 1980 John Andrews case, and as being a very memorable case in which you were involved. And in that case, I'll just quickly give a précis of it. The jury awarded Mr Andrews, an architect, a then record total of $280,000 against 3 newspaper publishers, including $150,000 against John Fairfax over a report about the roof of a Canberra building. And then there was a settlement, it says here, presumably for a lower amount, while a High Court appeal was pending. Now, it quotes you here. You said that case set a benchmark in the way plaintiffs would conduct their cases. There seemed to be a bigger shift to the hurt feelings aspect. And I'm very interested to know about this hurt feelings aspect as part of this, what you were talking about, this sort of shift towards the winner as opposed to getting at the truth. How much of this aspect, the hurt feelings aspect, has contributed to that shift, if you like, towards getting to the winners rather than the truth?
I don't know whether that's the chicken or the egg, but I do remember saying that, and I do remember that case, and that was the case that, by the way, established Michael McHugh as a member of my pantheon of giants, because he appeared for John Andrews and was just a superb performance. And that was the case in which there was immense emphasis upon how Mr Andrews was hurt by what was published. And I think that was the case where the expression, I couldn't finish my egg at breakfast when I read the newspaper, first appeared. And it's amazing how many plaintiffs thereafter couldn't finish their egg at breakfast when they read the allegedly defamatory article. But hurt to feelings received emphasis in that case and no doubt accounted for a great part of the verdict. The damage to reputation was found by the jury, obviously, and Mr Andrews gave evidence, and evidence was called as to his international reputation as an architect. But thereafter, I did notice that you might get a plaintiff with a small libel but an immense component of hurt to feelings. At the time of the litigation of the Andrews case, there was a big libel and big hurt to feelings. Of course, Mr Andrews, to my recollection, was not named in the articles. Whether that played a part in the emphasis on hurt feelings, I don't know. But during the boom period, that was the early 80s, late 70s, 80s, and before the abolition of juries, in effect, you found the lesser the libel, the greater the hurt to feelings, was the line taken by plaintiffs.
Do you suppose at all that what was actually also happening was that we were starting to emulate a little bit more of American-style litigation, and perhaps that might have been a part of it?
I think what we were starting, but weren't aware of it, by emphasis on hurt to feelings, was looking at a defamatory publication as an invasion of privacy rather than as damaging to this notion of reputation. That's what I think. It was beginning in the late 70s and early 80s by the emphasis on the truly personal hurt to feelings. How dare you intrude into my life by publishing what might in fact be a trivial matter? I'm entitled to live my life without this being broadcast, and I'm profoundly hurt by the fact that you've done it. That would be the line, which is pretty close to an argument, you've invaded my privacy.
I suppose the trouble is with the celebrity spotlight being as it is, and increasingly over these last 20, 30 years, people now view invasion of privacy and their reputation as synonymous. In other words, you can't separate the two.
Yes, I'm sure they do. They are distinct matters, but the notion of celebrity has blurred any boundaries.
Do you think that's the main cause of the problem now, for the explosion of... I mean, there were many defamation cases, and as you were saying earlier, you were very busy. But I imagine now, if you were starting all over again, you would be overrun.
Well, I don't think there is the defamation industry is as busy as it was when I was the defamation list judge, let alone when I was at the bar, because of the reforms of 2005 limiting damages and so on, and the greater defences available. That's why there's this desperate search for a remedy other than libel or defamation. And public people are more conscious of the notion of their own privacy than ordinary non-celebrities are. There was a wonderful definition of a celebrity as a person well known for their well-knownness. You know that one, yes. And, I think that applies today.
And that, of course, is pretty tenuous ground, I suppose,
yeah.
for saying, well, you are well known because of, and sometimes it's true, they're only well known because they're well known.
No, yes.
That's right. Yes, but it is interesting because I'd like to turn to this. You have been described as someone who had a great deal to do with some of these defamation law reforms. You have been described as someone who brought a strong common sense aspect to defamation law, if you like. Now, I wondered, does that have to do with something you're quoted as saying here, that you said, most cases in my experience are usually resolvable on the basis of 4 or 5 questions of fact to which you apply 1 or 2 principles of law. And, I mean, you were mainly decrying that sometimes now, these days, it can take years before that point is ultimately reached. Is that what you tried for with your defamation law reforms?
Yes, I can remember, I think I was invited to launch the Journal of the University of Technology, UTS's law school, and that was in 2000, I think. And that's
before you became an adjunct professor there?
Yes. And that's when I spat the dummy about the sterile technicalities that have developed in the law of defamation, and made that statement about, at the end of the day, it's usually dependent upon 4 or 5 facts to which you apply the law. But the process of getting to that point took years and years, and it was absurd. And that's what I sought to do when I was conducting the defamation list, was to try and let common sense prevail over the obsession with technicalities. The level of success I'll leave to others to judge.
Well, I did want to know, though, how much success did you feel you actually had?
Well, actually, I with due lack of modesty, would say that I thought I did a pretty good job. And the defamation list was comprised of a club, as I presume it still is. It's passed on from generation to generation. But the council and solicitors became more focused, less time was wasted. It was a very highly serviced list, which caused a lot of anxiety in other areas of the law, which felt that too much service was being given to this defamation list. But it had to be serviced because you can't stop people from suing. But I'd like to think that I did calm it down and get people to think rationally and sensibly about what the real issues were and whether it was absolutely necessary to do X, Y and Z and so on.
I really would love to know, how did you do it? Because you make a very good point there about drawing it down to several key principles. You also make a good point about getting rid of distractions and technicalities. But I could say that, and yet could I do it? How did you do it?
By trying to be nice and reasonable is one way of doing it. So do you really, really mean you want X, Y and Z? Let's have a look at this. It wasn't an interventionist approach. It was more a mediating or conciliatory approach that I tried to get. Operating. I must tell the one story about, he's still called Young Clive, who's still so busy and so much in demand, and still one of the most imaginative advocates in that field. I can remember one day, Young Clive was in my court, and he was going on and on and on. And I don't say that in a disparaging way. He was talking and talking and talking, putting every point. I said, Mr. Everett, let's boil this down to one thing. What is it you really want? And he said, justice, Your Honour. And I said, well, you've come to the right place. And of course, the courtroom just broke up, and that was a wonderful thing, and that was part of the creation of an atmosphere of goodwill that I wanted to establish, rather than this terribly intense adversarial approach that hitherto seemed to apply. It became terribly personalised between Advocate A and Advocate B, so you try and calm that down.
Was this in a way owing to any situations when you were at the bar, and later on, of course, when you took Silk in 1984, were you in situations where you saw judges, or you appeared before judges who, for all kinds of reasons, could not see the wood for the trees, and in a sense, without even meaning to, maybe have contributed to that strongly intense adversarial atmosphere that you were describing?
Yes, I think that's right. And one thing I tried to do for myself was give meaning to this proposition that the last thing litigants should have to be concerned about is the identity and personality of the judge. In other words, you don't anxiously look up the list to say, my goodness, we're appearing before Justice Bloggs. He's absolutely impossible. That should be irrelevant. All judges should be. Even if they're boring, they should be the same. And their demeanour, their personality should not be a factor that affects how the litigants conduct their cases. So I tried to be such a judge as, they'd walk in and I wouldn't be there in that sense. As, my goodness, this is the Levine factor here. I'd like to think I was successful in that, but I certainly feel that now we're in a generation of celebrity judges, which in all courts, and that's very sad because the name is nothing. It's how you perform the role that's the important thing.
I suppose that's in part because now judges' peccadillos and styles are much more publicly discussed, and in a way you could almost say that's ripe grounds for defamation at times. But all the same, barristers I've interviewed, nevertheless, they did have their own views about judges behind the scenes, and ones I've interviewed have spoken about some judges long dead, and they've said, we didn't want to appear before Judge so-and-so because he always got the wrong end of the stick or something like that. And I imagine some of that personal feeling may have, in fact, trickled over to their clients, and so their clients might then become perhaps a bit imbued with, oh dear, we've got Judge so-and-so, what are we going to do?
That happened. There are judges, amongst the judges long dead, was one district court judge who virtually made up his mind when the appearances were announced, so that if one side had a non-Anglo name and the other side had an Anglo name, you know what the result was going to be. It was outrageous. But that type of thing did go on. And that was outrageous, and it was extreme, and it was uncommon, but it was there.
He couldn't be shuffled aside?
No, I had to wait till he retired and in due course died. In fact, I can't name him because I can't even remember his name, but I remember that fact about him. Judges now, it seems to me, seek comment and publicity about their cases or about their roles. There's nothing wrong with judges talking about the judiciary. I think it's very important that people learn about it. But it seems to be terribly personalised. I don't like it. I'm not going to name anyone. Yes, I'll say that. I better be prudent and stop there.